Hello and welcome back to our lectures on due process and incorporation. And this time we're going to be talking about 20th century definitions. If you've been paying close attention, you'll notice that I didn't follow my overview here. So I did for before ratification with Barron and Scott, and then initial interpretations in Slaughterhouse. And then for the last lecture on 19th century due process, I included twinning in there. Twinning was decided by the court, I believe, in 1937, 1932. So it is not a 19th century due process case, but it certainly does constitute a turning point and looks very much like those 19th century cases. And so I actually made a decision to switch it over into the 19th century lecture and forgot to update my overview. But for this lecture, we're going to be talking about two cases called Shelley and Duncan. One case, Shelley, involves a due process right to property ownership. In the other case, Duncan, involves a right to criminal procedural due process. So two very different cases, but both of which have real importance for defining what due process is. And then our last lecture will be on modern due process. Okay, so post Palco, what happens? I mean, we talked about twinning and then we talked about Palco. But what happens post Palco? Well, the court is fully committed to the doctrine of selective incorporation. So let's get a real handle on what that means. So to incorporate, simply in this context anyway, simply means to apply. Now, incorporate means something else when you're talking about creating a corporation to do business or something like that. But incorporate in this context simply means to apply. In other words, to take a right that we're committed to in some shape or form, either in writing or because we simply are historically, and to apply it to the states to limit their power through the Due Process Clause of the 14th Amendment. So think of the 14th Amendment Due Process Clause as kind of like a filter. And only the fundamental rights, only the most important rights, get through that filter and get applied to the states to limit their power. Now, the real question then is, what creates the filter? I mean, how do we know what is fundamental? And the court has been spending a good deal of time trying to decide that and trying to figure it out. It's interesting to note that in our second case, Duncan, Justice Byron White attempts to bring all of those cases together, all of those different definitions for that second point in Hurtado. He did it because he knew that undergraduates would be studying this stuff, and he just wanted to create a nice summary for you. So make sure you look at that pretty closely. Okay, the second thing is that if you'll look at table 3-1 in the reading I assigned for this week, you'll see a list of provisions that the court has incorporated and what cases it did it in. So you'll see there for the First Amendment, free speech was incorporated through a case called Gitlow, freedom of assembly through DeJonge v. Oregon, freedom to petition through Hague v. CIO, free exercise of religion, which we'll get to later in this course, and Cantwell, etc., etc. And you'll notice that virtually all of the provisions of the Bill of Rights have been incorporated. Down at the bottom, it gives us a list of those that remain unincorporated. The Third Amendment right against quartering soldiers, the Fifth Amendment right to grand jury hearing, we know that from Hurtado, the Seventh Amendment right to a jury trial in civil cases, and the Eighth Amendment right against excessive bails and fines. So you'll notice then that double jeopardy under the Fifth Amendment was incorporated in a case called Benton versus Maryland. I think the text of the reading I assigned for this week says that Benton overturned twinning v. New Jersey, and that's just simply not the case. Twinning is still good law. Benton deals with the kind of double jeopardy where the state is just trying to wear you out. Twinning dealt with the error correction kind. So look those over, and one thing to note is that selective incorporation, this case-by-case determining of whether some provision in the Bill of Rights is fundamental to the concept of ordered liberty, lies at the base of our political and civil and political institutions, etc., etc. That process of determining case by case whether these provisions contain fundamental rights ultimately ends up with, if it goes on long enough, in close to total incorporation. I mean, the last right that we incorporated to the states to limit their power through the Due Process Clause of the 14th Amendment was the Second Amendment right to bear arms. We've incorporated virtually all of the Bill of Rights and also included some rights that aren't contained in the bill. It's important to note. Okay, so our first case is Shelley versus Kramer. This was a case involving civil rights. It involved an attempt by Caucasians to limit where blacks and whites live to keep them separate. Now, in a previous case, the Supreme Court had struck down an ordinance passed by the city of St. Louis, Missouri, that mandated that blacks could only live in a certain area of the city and whites could only live in these other areas. The Supreme Court struck that down because that was state action. Clearly, the state was mandating through its city government that blacks and whites must remain separate, and they could not purchase property in certain areas. And the court said, nope, that can't be done because property rights are more important than separate but equal. So they tried to get around this in Shelley v. Kramer by writing restrictive housing covenants into the deeds of property. And these restrictive housing covenants said, if you buy this house, this piece of property, you agree not to sell it to anyone who isn't Caucasian for the next 50 years. Some people decided to sell their house. They were living in a white neighborhood in their city. And actually, Shelley v. Kramer involved a number of these cases. It was consolidated. Some of them involved the District of Columbia. Some involved Kansas City, Missouri, Kansas City, Kansas, other cities around the United States. But some people decided to sell their house, and they sold to an African-American couple, the Shelleys. And the Shelleys moved into their new house, and they're very happy with it, until one day there was a knock on the door, and it was a lawyer from a law firm that specialized in enforcing restrictive housing covenants. He said, there's a restrictive housing covenant attached to the deed of this home and its property, and it said that the person who owned it before you could not sell to anyone who is not a member of the Caucasian race. They sold it to you, you're clearly African American, and so what we're going to do is we're going to unwind this sale. We're going to wind it back. You're going to get your money back, but you have to give up the property. And if you don't agree to this, we're going to sue you. Well, the Shelleys didn't agree to it. And they said our property rights are more important than this restrictive housing covenant in this deed. Well, the response on the other side was, there's no state action here. This is private. This is a private property. This is a private agreement among private individuals, and it's part of the deed of this house. And so we're not mandating anything through legislation. We've just made this agreement as part of creating this home and assigning it a deed. Well, the Supreme Court wasn't having any of that. They found state action, and they said, you can make these private agreements all you want, but as soon as you get a court to enforce it, that's where the state action is. Courts may not enforce the provisions of these restrictive housing covenants. Private individuals can get together and make agreements among themselves not to sell property to anyone except a Caucasian person. but courts can't enforce it when members violate the agreement. So state action then involves Congress remediating the actions taken by states. The Congress can't command the states, it can only change the way a state does things to conform with due process in the 14th Amendment. And so a lot of people interpret Shelley v. Kramer as a state action case, and they say, no, the Supreme Court found state action and it was in the enforcement of these private restrictive housing covenants by state courts. Well, if you read what I assigned you carefully, you'll notice that property rights are important in the court's decision. The court uses property rights to overcome what states have been using to justify keeping the races separate in a variety of areas. We call this the social order justification. And in earlier cases, the Supreme Court had accepted a state's judgment that to maintain social order, the races had to be kept separate. They accepted this as a justification for non-neutral laws. The most famous of these cases was Plessy v. Ferguson, in which the court accepted a social order justification for a non-neutral law keeping the races separate in transportation. But here the court says, no. Property rights are more important than social order. Property rights are the foundation of Western civilization. And the court traces, I think this has been excerpted from what I assigned you, but in the full opinion, the court traces property rights all the way back to the Norman invasion of England and says that even then, the Normans passed laws that said that a whole class of people can't be prevented from owning property. And so they use that logic to say, yeah, social order might be good for water fountains, might be good for golf courses and beaches, might be good for restrooms, and it might be good for schools, but it is not good for where people buy property. Okay, well, our last case is Duncan v. Louisiana, and as I said before, this is an excellent summary of the expansion of the Hurtado test's second point right at the very beginning. If you read it on page 81, you can see where he goes through all of the cases. Let me just read this down for you. The test for determining whether a right extended by the Fifth and Sixth Amendments with respect to federal criminal proceedings is also protected against state action by the 14th Amendment has been phrased in a variety of ways in the opinions of this court. Well, that's an understatement for you, and we've been through those cases. The question has been asked whether a right is among those, quote, fundamental principles of liberty and justice which lie at the base of all our civil and political institutions. Oh, he's quoting Hurtado there. Whether it is basic in our system of jurisprudence, and whether it is a fundamental right essential to a fair trial. There, the second one, basic in our system of jurisprudence, he's quoting Palco and Twining. The claim before us is that the right to trial by jury guaranteed by the Sixth Amendment meets these tests. And so he's framed this up very nicely in light of 19th century and early 20th century cases. So this case is about a procedural guarantee of a right to a jury trial. And the court uses the Hurtado rule expanded by Palco and Twining. It uses this rule for determining what is a fundamental right. And the court, when applying this rule, concludes that the Sixth Amendment trial by jury right is fundamental for serious offenses. So you can't claim a right to trial by a jury for like a parking ticket. But when the when the state has charged you with a serious offense, then a trial by jury is a fundamental right, and you have a right to ask for one. We didn't talk about Duncan very much, but read it very closely. The facts of it are pretty interesting, and it involves individual who is accused of a crime. The accusation may be racially motivated, and then Duncan asks for a trial by jury, which the Judge denies him that, and actually he did it properly under state law, because the state law didn't allow Duncan to have a trial by jury. And the court concludes, after applying this definition of what is fundamental, what's a fundamental right, to the request for a trial by jury, to incorporate the trial by jury right through the Due Process Clause of the 14th Amendment, here's what the court says. Our conclusion is that in the American states, as in the federal judicial system, a general grant of trial for serious offenses is a fundamental right, essential for preventing miscarriages of justice and for assuring that fair trials are provided for all defendants. We would not assert, however, that every criminal trial or every particular trial held before a judge alone is unfair, or that a defendant may never be as fairly treated by a judge as he would by a jury. The court incorporates this right for serious offenses and says that it's important that this right, once considered fundamental, be applied to limit the power of the states. And so it applies this right to the states. And if you look back at Table 3-1, under the Sixth Amendment, jury trial, you can see there's Duncan versus Louisiana listed right there, 1968. Thank you very much for your attention, and we'll move on to the final lecture, which is on modern tests and doctrines.